Absolutely. Here's a breakdown of the history of Indian environmental laws, divided into phases for clarity. Pre-1972, scattered legislation. Early focus. In the beginning, environmental legislation in India was limited and mainly focused on specific resource management or nuisance control. Here are some notable early laws. Indian Forest Act, 1865, aimed at consolidating control over forests for commercial exploitation. Shore Nuisance, Bombay and Colaba, Act, 1853, designed to manage the pollution of Mumbai's coastal waters. Indian Fisheries Act, 1897, focused on regulating fishing in certain freshwater environments. Constitutional recognition and a turning point, 1972 to 1980s. Stockholm Conference, 1972, India played a major role in the UN Conference on the Human Environment in Stockholm. This watershed moment spurred legislative action toward environmental protection. Constitutional amendments. The 42nd Amendment to the Constitution of India, 1976, explicitly incorporated environmental protection. Article 48A directs the state to protect and improve the environment. Article 51A, G, imposes a fundamental duty on every citizen to protect the environment. Post-1980s, era of major environmental legislation. Bhopal gas tragedy, 1984. This devastating industrial disaster was a major catalyst for significantly strengthening environmental laws in India. Key legislation. Water, Prevention and Control of Pollution, Act, 1974, provides a framework to prevent and control water pollution. Air, Prevention and Control of Pollution, Act, 1981, similar to the Water Act, but focused on preventing and controlling air pollution. Environment Protection Act, 1986, the most crucial piece of legislation, serving as an umbrella act, under which many important rules and regulations were framed. This act provided the central government with broad powers to protect the environment. Judicial activism and evolving principles. The role of courts. The Indian judiciary, particularly the Supreme Court, played a pivotal role in enforcing environmental rights and interpreting environmental laws. Through landmark cases, they established key principles. Polluter pays principle. Those responsible for causing pollution bear the cost of remediation. Precautionary principle prevents environmental harm in the face of scientific uncertainty. Public trust doctrine. The government acts as a trustee of natural resources, holding them in trust for the public. Recent developments. India continues to develop a robust system of environmental regulations. Here are a few significant advancements. National Green Tribunal, 2010, specialized court set up to handle cases related to environmental protection. Biological Diversity Act, 2002, enacted to conserve biological diversity and ensure its sustainable use. Solid Waste Management Rules, 2016, provide a framework for handling and disposing of solid waste effectively. Key challenges and considerations. India's environmental laws face hurdles such as implementation. Insufficient monitoring and enforcement of regulations continue to be issues. Balancing development. Managing environmental protection alongside economic growth remains an ongoing challenge. Awareness and participation. Increased public engagement and awareness of environmental issues are critical. Let me know if you want a deeper dive into any of the historical phases or individual laws.